So Bill is Acting Chief Parliamentary Counsel. So all he does all day is think public law. He thinks public law, he thinks about policy behind legislation, he thinks about bills and the drafting of bills. And he, of course, has a very extensive knowledge because he is supporting the government's legislative program. So last year, under his guidance, the Parliamentary Counsel Office drafted 83 government bills, 491 statutory regulations, a number which reflect a dramatic increase in the annual legislative program. So of note, under Bill's watch, the Parliamentary Counsel Office was required to draft urgent legislation in response to the Canterbury earthquake. So Bill is important because if he gets it wrong and it's applied to you, it will not be good. Bill, come and talk to us about what you do.
Thank you, Mai. Last night I started watching a DVD and I picked up your book at the same time, Mai, and I can report it was at least as gripping as the DVD because I'd skim-read through to page 200 by the end of the DVD. So, it's fair go. It was quite a good movie. So there you are. You've got the rare compliment of a book which is at least as gripping as a DVD and highly readable as well. I'm going to select 4 characteristics of good legislation. The topic is why is good legislation important. There are many more characteristics, some of which are in conflict. And the first one I've chosen, the legislation should work. Why is that important? There's really 2 issues in that. Legislation that does not achieve its policy objectives wastes everyone's time. Wastes Parliament's, the government's, your time, the sections of the public who are required to implement it. I think there's one exception to that. Some legislation, the passage of which is an end in itself, a lot of that emanates from coalition agreements where there is a form of words which basically covers irreconcilable concepts. It's a bit like the automotive equivalent of trying to make a milk tanker out of a hot rod and a station wagon. What you get at the end is an artistic sculpture which may be very pleasant to observe but not actually a working vehicle. So some legislation is in that category and it's purely a matter of political necessity and it's what politicians agree to pass things. Legislation that is technically deficient involves added burdens and costs of litigation, uncertainty of application, more parliamentary time spent fixing it, loss of reputation for all those involved in the process, officials, drafters, ministers, the government, and ultimately and most damaging, the reputation of Parliament. It also imposes costs on business and the public. If Parliament is seen to be a clown by the general public, the willingness of the public to participate in elections and generally respect our system of democracy is undermined. Sometimes controversial legislation is actually quite workable. And I mention a controversial act in 2003, the Electoral Vacancies Amendment Act. It arose from the former Member of Parliament, Honourable Harry Duynhoven, taking up Dutch citizenship. The general policy statement was 14 lines long. It clearly identified the issue. It can be expressed in one line. The policy of this bill is to ensure that the seats of members elected to the 47th Parliament are not vacated by operation of section 55 1B and C of the Electoral Act. Had I been very bold, I probably could have added in another line somewhere saying that it is inconvenient to the government and unfair to Mr Duynhoven for him to lose his seat because of a technical issue. It was enacted as a temporary measure. It's very simple. It just says section 55 1B and C of the Principal Act do not apply to any Member of Parliament, and then for all purposes the question of whether the seat of a Member of Parliament became vacant before the commencement of this Act must be determined as if section 4 had come into force on 14 August. So in some ways this meets the characteristic of good legislation. It worked. Mr. Dijnhoven served out his term. The purpose was clear. Of course, it did excite comment from academics, particularly was Dijnhoven dodgy, an article from a visiting American professor saying was fundamentally constitutionally flawed. So good legislation is workable, but the fact that it is workable does not automatically make it good. Second point, the legislation should be written as clearly as possible and accessible to its intended audience. Why is this important? The late George Tanner has said that a government cannot expect citizens to obey the law if they do not have access to it. One part of that access is physical access, including free internet access. Another part of access is that the citizen should be able to comprehend the nature of the obligation imposed on him or her as a citizen. In my view, a Year 10 student who's age 14 should be able to read the offences against the person and property offences sections of the Crimes Act and get a general gist of what they are or are not allowed to do, because that's the age of criminal responsibility. However, a citizen who engages in business involving structures of companies and trusts will almost invariably need the services of professional advisors. So the complexity will vary with the context. I think somewhere where we may have got it wrong, there are a lot of acts imposing obligations on the trades which involve multiple layers of documents, and where we're asking people with school certificate or NCA 1 to master very complex schemes. That's an area. I'm going to end on one topic. The explanatory material and drafting style of legislation should not seek to confuse or obfuscate the true purpose of the legislation. An example of what by modern standards is startlingly plain drafting is found in the preamble in the New Zealand Bill of Rights Act, which is still part of our law. Whereas the late King James II, by the assistance of diverse evil counsellors, judges and ministers employed by him, did endeavour to subvert and extirpate the Protestant religion and the laws and liberties of this kingdom by, amongst other matters, a long list, by violating the freedom of election of members to serve in Parliament, and excessive fines have been imposed and illegal and cruel punishments inflicted. You can read that now, anyone can read it. It makes perfect sense 324 years later. It is pejorative, but the mischief at what the legislation was aimed is perfectly clear. I cannot find a general policy statement in my time which is as clear as that. My suspicion is that when we read a lot of these documents, such as regulatory impact statements, which Jonathan's going to talk about, we struggle to understand them now. In 3 years' time, we will say, what was that all about? But as an example to us, a piece of 17th century writing which is as clear now as it was then. Thank you very much.